Hello. In this video, we will walk through the electronic discovery reference model, which describes the stages that electronically stored information goes through in a standard litigation, arbitration, or subpoena response. Many of our other videos dig into the details of some of these stages, so be sure to review our list of videos for additional detailed information. The EDRM is displayed on your screen. Before we address the various stages, please note that the overall goal of the process is to reduce the volume of documents through the various stages while surfacing the most relevant information in accordance with the applicable rules of the jurisdiction. This video will not address information governance. Instead, we'll jump right into the identification section. This is where lawyers and client representatives from the business and from IT work together to locate the sources of potentially relevant information for the matter. This includes both custodial information, such as emails, file shares, documents stored locally on laptops, text messages or messaging apps, and even handwritten notes. The other sources of potentially relevant information include databases that the company has established for employees to store and share information, such as Dropbox or customized applications for a particular industry. In the construction industry, project documents are often stored in specialized systems such as Procore, Newforma, and BIM 360. Some clients may store their project files on servers within their own organization. Others may store data in cloud-based tools. Regardless of where the data is stored, the goal of this phase is to identify relevant information and ensure that it is not deleted or otherwise disposed of during the pendency of the matter. We then move into the preservation phase. In this phase, the counsel and the client ensure that the proper legal hold notices have been distributed to the relevant employees to ensure that documents and files that are needed for the matter are not disposed of. There is some triage involved in this phase, as many companies have automated time-sensitive disposals in place for certain types of information. It is very important that counsel and the client communicate with the relevant stakeholders to make sure that those automated roll-off practices are suspended, if necessary, to protect against the loss of relevant information, resulting in a potential spoliation claim by the opposing party. Not all information preserved may ultimately be collected for processing and the remaining phases of the EDRM. Sometimes the scope of the collected data is narrowed via negotiations by the parties during a meet and confer and embodied in an ESI protocol. It is often the case, however, that the scope of the data to be processed, searched, and filtered is not readily discernible at the early stage of the matter. Think of preservation as an insurance policy intended to protect the company against claims of spoliation by the opposing party. Preserve broadly, collect more narrowly is a phase you often hear in the eDiscovery world. Another consideration for the collection phase is who does the collection. In order to manage costs, some clients prefer to use in-house IT resources to conduct collection. Caution should be exercised here, as people conducting the collection may become witnesses in an eDiscovery dispute between the parties. Regardless of who conducts the collection, there should be clear documentation for the processes and technologies used to collect the data. The next phase of the EDRM is processing, which is handled by technical personnel with minimal oversight from counsel. This phase is necessary in order to allow counsel to review and analyze the documents in standard eDiscovery software, such as Reveal or Relativity. Included within the processing phase are various filtering tasks, such as removing system files, deduplication, and the application of search terms and date filters. The removal of system files is based on a standard list produced by the National Institute of Standards and Technology, commonly referred to as the NIST list. Deduplication involves the identification of identical documents using a unique thumbprint assigned to each document called a hash value. Hash values are a 26-character alphanumeric code. If documents have identical hash values, they are identical documents. To reduce the volume of documents to be loaded into a database and reviewed, Parties almost always agree to eliminate identical duplicates from review and production using hash deduplication. Parties also often agree to apply search terms to reduce the volume of potentially relevant documents to review. These search terms are applied during the processing and analysis phases. Parties may negotiate search terms and test them on the collected data in order to reduce the number of false positives that may occur, saving the parties costs during the review phase. The final phase of the EDRM is production. Ideally, parties should negotiate and agree upon production specifications prior to making any productions, taking into account the type of data, type of case, and the preferences and resources of each party. This agreement should be included in an ESI protocol. Early agreement is the best way to avoid costly eDiscovery disputes and reproductions. In the absence of agreement, disputes regarding form of production will be determined by the judge or arbitrator based on case law and any applicable rules of procedure. Now you know all about the electronic discovery reference model. Contact your consultant if you have any questions, and be sure to check out our other videos.